This video concerns Iowa unemployment compensation. It is a non-profit video. It is not sanctioned by the state of Iowa or Workforce Development. It is all from volunteer time. This is legal information and not legal advice. Now, the video today goes through the opening statement given by an administrative law judge in the state of Iowa at the appeal hearing level. Let me review how unemployment hearings start and what step in the process we're at right now. If an unemployed worker files for unemployment, they will receive a monetary record in the mail. The employer would then receive a notice of claim or protest form, Form 201A. The employer would then file a protest. There would probably be a fact-finding, although some issues do not require fact-finding hearings, and a decision would be issued. And once the decision is issued, the losing party has the right to appeal to get a full due process hearing before an administrative law judge. A hearing notice comes out, and the parties must read and follow the instructions if they want to participate. And now we're at the level where the parties are participating in an unemployment appeal hearing before an administrative law judge. And this is the opening statement. I'm going to go through this in fairly short order and then back up and explain the meaning of much of this document. First of all, once the parties are on the phone, each party would be asked if they had any other witnesses, and they would be asked if they've had a change in mailing address as a general rule. Then the record would begin, and proceed something like this, and I'm going to fill in the blanks. The time is 9:03 and the record begins. This matter, appeal number 11A UI 000XT comes on for hearing October 1st, 2011. The hearing originates at Des Moines, Iowa by telephone conference before Administrative Law Judge Roy Bean. The claimant, John Doe, is participating and has one witness, Jane Doe. The employer participates by the personnel manager, Jane Smith. The hearing is held pursuant to an appeal filed by the claimant from a decision of July 1, 2011, reference number 02, which denied benefits after claimant was discharged for misconduct on June 1, 2011. The issues include whether the claimant was discharged for misconduct under Section 96.5.2a, quit for good cause under Section 96.5.1, and whether there's an overpayment of unemployment benefits under 96.3.7. The procedure I'll use today is to ask questions first of the employer because the burden of proof is on the employer in a discharge for misconduct case. I'll ask questions of the employer first, then they can offer additional evidence and testimony. Then the claimant has the right to ask the employer questions. Then we go to the claimant. I ask questions first, then the claimant can offer additional evidence and testimony. Then the employer can ask questions. Finally, we go to the claimant's witness. I ask questions, then the claimant can ask questions, then the employer. And we go back and forth like that until the evidence is brought forth. Does the employer have any questions on procedure? Does the claimant have any questions on procedure? After I've heard the testimony and received the evidence, I'll issue a decision that will be mailed in about 2 weeks. My decision is final unless further written appeal sent to the Employment Appeal Board within 15 days of the mailing date of my decision. The mailing date will be stamped right below my signature on the last page of the decision. If there's an appeal, the Employment Appeal Board will not conduct another hearing such as this. The appeals from the record created today. They will not consider new or additional evidence unless you have good cause for not offering such evidence today. At this point, I'm going to place all of you under oath. Do you and each of you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Respond by saying, I do. All right, that's the end of the opening statement. Now, when someone puts you under oath, occasionally people will say, I don't swear. Please don't argue with the administrative law judge. Just say, I affirm. There's no reason for you to announce that you don't swear. If there's an interpreter in a hearing like this, the interpreter would, of course, be placed under oath before the opening statement starts, and then the administrative law judge would read one line, then it would be interpreted, one line, and then interpreted. Same procedure goes during the hearing if there's an interpreter. The parties always must wait for the interpreter. The interpreter goes first after every statement. Now let's back up on this. This hearing is pretty much just reiterates what is on the hearing notice. It tells who the parties are. It gives a title of the parties participating by the employer. it gives appeal rights and the right of cross-examination. And these are due process hearings, and the whole purpose of this opening statement is to let the parties know how the procedure works. But because the opening statements go so quickly, most people don't absorb the whole content and context of this. So the bottom line is, each party has a right to ask questions of the other side. The employer, if they have multiple representatives, one person is designated as a rep. That person gets to ask questions of their own witnesses and of the opposing party. Same thing for claimant. A claimant may designate a non-lawyer as a representative or may act as their own representative. And that representative then gets to ask questions of everybody else. The hearing is conducted by the administrative law judge, and all the questioning starts and ends with the administrative law judge, and most of the important questions are going to be drawn out by the judge. However, it's the claimant and employer's responsibility to draw out those things that the administrative law judge can't anticipate. Because the judge is coming into these blind. They have no background whatsoever. They probably didn't even open the file until a few minutes before the hearing, just because of the caseload and the way the caseload works at the administrative level. So questions are necessary. If you have good questions, the form of the questions must be in non-leading format if you're asking your own witnesses questions. For example, if the employer has a witness and they want to ask a witness a question, they can't use the statement, "Isn't it true the claimant stole money from the employer?" That's a leading question. The question should be, did the claimant steal money from the employer? When the same thing would go for claimant. When claimant wants to ask questions of employer witnesses, they can use leading questions. So the claimant can start most any question out with, "Isn't it true?" Same thing with employer when asking questions of claimant. Starting the question out with, "Isn't it true? Isn't it a fact? Isn't it so?" That's the easy way to do it, is to ask leading questions of the opposing party. The hard part is when you're asking questions of your own witnesses, and they must be a non-leading question. Did this happen? You kind of have to be careful not to imply the answer. As we go down through, really the procedure is the most important thing, and that each party gets a chance to ask questions, and that the judge will tell you when it's your turn. So listen carefully. They'll ask, "Do you have any questions for the other side?" And most parties make their mistake by simply thinking that's time for them to tell their story. It isn't yet. You get a chance to tell your story when the judge says, "Do you have anything else?" It's your turn to tell the story after the judge finishes asking you questions, not when the judge says, "Do you have questions for the other side?" Now, the final closing remarks gives appeal rights. And the appeal instructions are on an administrative law judge decision, so you can read the decision and figure out how to appeal. But most importantly, you're going to get a decision in fairly short order. Some decisions come out in a matter of days. Some take a few weeks to get out. If you want to appeal, you go to the Employment Appeal Board, and you have 15 days from the mailing date of the decision. 15 days from the mailing date to get your appeal on file to the Employment Appeal Board. Now, the Appeal Board doesn't give you another hearing like this. The Appeal Board reviews the case on the record. You don't get to offer new evidence unless you can establish good cause. And I've rarely seen the Appeal Board allow additional evidence. They might remand for a new hearing, but they don't. They generally don't take new evidence. You have to have your evidence at this level. This is the level where evidence is taken, because they don't consider new or additional evidence unless you have good cause for not offering it at the ALJ level. That's the basics of an opening statement. There's some nuances. Each administrative law judge will have a somewhat different procedure. It won't go word for word like this, but it should cover most of the topics. Sometimes exhibits are taken during the opening statement rather than waiting into the hearing. Some judges like to get the opening statement over, place people under oath, and take their exhibits at that time. And each judge has their own variables. But Now you kind of have a good understanding of how the procedure works, that you have the right of cross-examination, that with your own witnesses you can't use leading questions, and you have the right to offer exhibits, and you have an appeal time of 15 days from the mailing date of the decision, and you aren't going to get a chance to offer other evidence or give testimony again at the next level, which is the Employment Appeal Board. With that, I'm going to close this video, and good luck with your unemployment claim.